Mr. Stewart?
Thank you, Mr. Chief Justice, and may it please the Court. In Grokster, this Court held that one who distributes a device with the object of promoting its use to infringe copyright can be held liable for its user's infringement. In Twitter and Smith & Wesson, the Court emphasized that to be liable for aiding and abetting, a person must participate in the primary violation as in something that he wishes to bring about and seek by his action to make it succeed. Thus, both in copyright law and more generally, this form of secondary liability is reserved for persons who act for the purpose of facilitating violations of law. Because Cox simply provided the same generic internet services to infringers and non-infringers alike, there is no basis for inferring such a purpose here. I welcome the Court's questions.
Mr. Stewart, in Sony, Justice Stevens was clear that there was no secondary liability provision in the copyright law. And he relied on the existence of secondary liability in the patent statute and borrowed from that for his argument that there would be secondary liability in copyright. How much should we borrow from either patent law or from common law with respect to in developing our secondary liability jurisprudence under copyright?
I think probably the first place you would look is general principles of aiding and abetting law, which are common law principles. But if the Court thinks maybe intellectual property cases are different, it could look to Congress's codification of secondary liability principles in the Patent Act. And it's very clear that in patent cases, the Patent Act doesn't provide for secondary liability in circumstances like these. In the Patent Act in 35 U.S.C. 271B says, whoever actively induces infringement of a patent is liable. And Section 271C says anyone who sells a device that is specially suited to patent infringement, not capable of substantial non-infringing uses, with knowledge of its special character, is liable. There's nothing in the Patent Act that says if you sell a multi-use device to a person that you know is going to use it for infringement, you can be liable on that basis. So I think it would be unusual to adopt a special rule of copyright law and ignore the rule of patent law that Congress has actually adopted in the U.S. Code.
Do you read